Good evening, everybody, and welcome. So first of all, I really thank you very much for joining us on what is a lovely sunny evening. My name is Sam, Dr. Sam Bell, and I'm one of the medico-legal advisors at the MDU. I've been a medico-legal advisor for just over 9 years, having spent a number of years before that in clinical practice. And this evening, I'd like to introduce my colleague, Mr. Ian Barker. And this evening, Ian will be giving us an update on gross negligence manslaughter. So just a little bit about Ian. Ian is a solicitor with over 35 years of experience in healthcare law and has been a senior solicitor at the MDU for over 23 years, specialising, amongst other things, in criminal and regulatory matters affecting doctors. Over the course of his career, Ian has acted for many hundreds of doctors in police investigations, including more than 100 cases involving the deaths of patients. He has extensive experience of representing doctors in GMC proceedings. Ian has successfully defended doctors prosecuted for homicide offences, acting in the leading manslaughter case of R.V. Prentice and Silman, involving intrathecal administration of vincristine, and I'm sure that's a case that many of you will be familiar with. Also the trial of Dr. Dave Moore for murder, the so-called wrong kidney case, and a double manslaughter prosecution of a GP following inadvertent overdoses of morphine to 2 patients. More recently, Ian gave evidence to both the Williams and Hamilton reviews in relation to gross negligence manslaughter. So before I hand over to Ian, I just wanted to say a few more words about this evening. During the webinar, please ensure you put any questions in the questions box, and I can't promise we will answer all of them, but we will do our best to address some of them at the end, so we've got some time for questions. I've also been asked to let you know that a feedback form will appear at the end of the webinar, and we would be grateful if you would let us know your thoughts and comments, and that's really helpful for us. And once you've done that, in return, you get a certificate of attendance via email. The webinar will be recorded, and I think that a copy will be sent afterwards by email as well. So finally, I appreciate that tonight's subject matter may sound extremely daunting, but I think it's important to remember that whilst it's one of the criminal charges that members may potentially face during their career, it really is the rare one. And on that note, and without further ado, over to Ian.
Sam, thank you very much indeed. Well, what I'd like to do, if I may, in trying to give you the update, is to explain a little bit about the law and quite where we are at the moment and the journey that we've taken over recent years. A little bit about how some changes have come into effect, which may be beneficial, and indeed a little bit about the process too, if I may. So starting off, I'm taking you all the way back to 1329. That may seem ridiculous, and indeed you're entitled to think, well, this man was giving us an update, he's an idiot. Well, I take you here simply because this is the first prosecution I've been able to find of someone who is described in this yearbook report, as it is, a man of certain professional skill, prosecuted for the death of a man under his care. And it's, I think, quite right to think that the issue of gross negligence manslaughter is one particularly for the medical profession in our times, but it just shows that it's been going on for a very long time indeed. Well, you'd like to move forward, I'm sure, and let me take you, if I may, to the case of Williamson in 1807, and I do so in some ways to show how little manslaughter, at least as a clearly defined concept, changed from this point moving forward until fairly recently. This particular case involved someone described as a man midwife who tears away part of the uterus thinking it's placenta, resulting in the patient's death. And the Lord Chief Justice in this particular case directs the jury that in order to substantiate the charge, the defendant must have been guilty of criminal misconduct arising either from the grossest ignorance or the most criminal inattention. And as I'm suggesting, I don't think for probably about 200 years we moved forward very much in terms of an understanding in relation to gross negligence. Interestingly, the Chief Justice in this particular case made this additional comment, essentially pointing out that people are going to be deterred from entering a profession if indeed there's a guilty verdict. It's a good steer for a not guilty, which indeed Mr. Williamson was duly found to be. But at least some prescient thoughts, one might think, from the Lord Chief Justice in that particular case. And one rather wishes that judges perhaps had been more of that mindset in recent years. Well, the law develops through the 19th century, and interestingly, a number of the cases which are there to indicate what the law is are medically related. And it seems to me from looking at the reports that judges struggle in some significant way to explain and formulate what's meant by criminal negligence. There are references to an evil mind, something that's greater than mere civil negligence. Well, that's not an awful lot. And indeed, in one case, contrasting a slight want of care with a drunk surgeon. It really doesn't take one very far in terms of having a suitable, or at least a substantive definition. And we then move to what I think most lawyers would regard as being a starting point for the present foundation of gross negligence manslaughter, and that's the case of Dr. Percy Bateman in 1925. Now, Dr. Bateman does something which is really rather similar to that which Mr. Williamson managed to achieve 100 years previously. And in relation to that, plainly, has a dreadful time of it, the patient an even worse time of it, and he is convicted of gross negligence manslaughter. And his case goes on appeal to the Court of Appeal, where Lord Hewitt makes the point that judges over the period have used many descriptions for gross negligence, culpable, criminal, gross, wicked, clear, complete. But he then says whatever descriptions used, essentially, it has to be something. The negligence has to go beyond a mere matter of compensation and shows such disregard for the life and safety of others as to be a crime. Well, that's fine. It does seem to me, though, that that doesn't really take things very far. And indeed, the test, as per Bateman, has been described as circular. Indeed, it is. Essentially, what is criminal? Well, that's something that's gross. What's gross? Well, that's something that's criminal. And again, it's not taking one very far, and hence my suggestion that over a period of time, the law really isn't developing very much, certainly to this point. Well, where are we now? The leading case on manslaughter, gross negligence manslaughter, is that of Dr. Adamoko from the House of Lords back in 1994. And the House of Lords in this particular case sets out the component parts. Again, whether it takes one very much further in terms of a clear understanding is perhaps debatable. But let me walk you through the component parts as were identified in this particular case involving an anaesthetist who had failed to appreciate that the anaesthetic equipment had become disconnected from the patient. Well, first off, the existence of a duty of care. Secondly, a breach of duty of the care to the patient. Thirdly, that the breach caused or materially contributed to the death of the patient. And so far, essentially, one has the component parts for simple civil negligence. Next, that the breach of duty involves a serious risk of death, which would have been obvious at the time of the breach. And then finally, and perhaps the most important part in many cases, that the negligence was so bad that it should be categorized as criminal. It seems to me that although it's all very well to have those 5 component parts and helpful, it doesn't actually take you very far, certainly very much further. What Lord Mackay, the Lord Chancellor, said in delivering the lead judgment in Adamoko was that the matter essentially is supremely a jury question in terms of having regard to the risk involved. Was the conduct of the defendant so bad? And I've highlighted the words "in all the circumstances" for a particular reason, because sometimes I think people become concerned at the fairness of a process where there is perhaps no regard apparent to systems failures that there may be, or the intervention of others who may not have had their best day either, contributing to what happens in terms of the outcome. And it's not just the conduct of the defendant that ought to be considered. And this, in all the circumstances, is an important point to remember. What the defendant has done is, of course, crucially important, but it has to be judged in the surrounding circumstances, and systems failures clearly come into play in those within that. Well, the difficulty, it seems to me, after Adamoko is that one's still left with the question, how gross is gross? No specific formula is expressed about how bad something has to be, and indeed, Mackay said, an elaborate description isn't really felt desirable. essentially it's down to the jury to determine, which leaves, I think, again, a far from satisfactory position. Well, how's that applied? Well, one comes to the case of Dr. Becker. Dr. Becker was convicted of GNM, if I may call it that. In relation to his trial, the judge told the jury 4 times they had to find the negligence criminal, and indeed reminded the jury that mistakes come in all shapes and sizes. Doesn't make any reference to a civil wrong as a comparator. So it's not saying, look, it's going to go way beyond mere civil negligence. None of that, just it's criminal 4 times and mistakes come in all shapes and sizes. The Court of Appeal, obviously looking at the Adamoko judgment where there is no specific judgment, no specific direction required, says, well, that's Adamoko compliant. And I have to say, I think that was a lazy and thoroughly inappropriate decision on the part of the Court of Appeal, for reasons that we can come to. But the bottom line was it was considered Adamoko compliant, and Dr. Becker's conviction was upheld. Interestingly, 3 years earlier, in the case of Litchfield, there'd been an unreported Court of Appeal decision. I think in these days with everything online, it's easy to think that everything is reported. But back then, not every case would come to the attention of lawyers as a reported case in a law report. And this one slipped by, but it did come into prominence subsequently. It involved, and this may be part of the reason why it started in obscurity, a rather arcane aspect of maritime law. But the defence had also been prosecuted for gross negligence manslaughter. And although the appeal dealt with the issue as to what the maritime law was, the Court of Appeal, when it dealt with the matter on appeal, passed comment in relation to the direction that the judge had given on manslaughter. And in that case, the judge had said that the negligence must go beyond mere matter of compensation. It must demonstrate a reckless disregard for the lives of others, of such a nature and to such an extent that negligence is so bad it can probably be criminal, and continuing the conduct was so bad, so obviously wrong, so reckless. That's what's required. And one has an element here of it being laid on a little bit thicker in terms of quite what's required. Certainly something that was infinitely better than the direction which was given in the case of poor Dr. Becker. And one then comes 6 years later, in 2003, to the case of Doctors Misra and Srivastava. They found themselves on trial for gross negligence manslaughter at the Southampton Crown Court. And Mr. Justice Langley then gives a direction to the jury, which is, I think, even stronger. He makes the point that mistakes, even very serious mistakes, and errors of judgment, even very serious errors of judgment, are nowhere near enough for a crime as serious as manslaughter to be committed. And he continues that effectively to find guilt, they'll have to find that the conduct fell so far below the standard to be expected that it was truly exceptionally bad. So we have mistakes, even very serious mistakes, serious errors of judgment, nowhere near enough. It has to be truly exceptionally bad. Strong stuff. Sadly, the irony was that, of course, Doctors Misra and Srivastava were convicted, and although on appeal that was upheld, what was at least taken away from that was an approval by the Court of Appeal of this particular formulation. It found favour with the Court of Appeal. But we then had a rather curious position. You don't know what explanation is going to be given by a trial judge to a jury. Is it going to be a Dr. Becker type formulation? Is it going to be a Misra or a Litchfield approach? And I have to say what we tended to do in cases after that was to make jolly sure that towards the start of a trial, the trial judge would be given the Court of Appeal judgments in Misra and Litchfield, so that the judge could give some early consideration to the formulation that was going to be applied in due course in the judge's direction to the jury. And indeed, to take a couple of examples, in the case of Dr. Nika, a GP prosecutor, and Dr. Kakani, they had the benefit of a Misra / Litchfield type formulation, both of them being acquitted. Well, where were we in relation to the problem with GNM up to a few years ago? Well, as a starting point, we didn't have, in my view, adequate guidance to coroners in terms of what amounted to gross negligence manslaughter. There was a law note available from the Chief Coroner. I'm bearing in mind this is being recorded, trying to be polite about the law note. Let me say I wouldn't give it many out of 10. It was perhaps most politely be described as out of date. And part of the difficulty here and why it's relevant is that, of course, as a referral mechanism, coroners are under an obligation not to plough ahead with an inquest where they consider there could be criminality. If they consider that there is that potential, they should refer the matter to the police. And it, I fear, did contribute, or at least, let me perhaps put it more fairly, there was a situation in which an awful lot of the referrals for investigation to the police would be coming from coroners. Another problem was that there wasn't any strict requirement for the police to take CPS advice. There was not a clear statement of the law from CPS, and perhaps not best assisted by the fact that the law wasn't arguably particularly clear. Regrettably, there were a significant number of cases being investigated after coronal referral. And of course, the difficulty is that even if those cases aren't prosecuted, going through the investigation process is profoundly stressful for anybody involved. And indeed, the complexity of the cases, because these cases are necessarily complex, can lead to significant delay. So people really hanging out their hoop, if you will, for a prolonged period under investigation, not a satisfactory situation. Well, where were we with the odds in terms of the potential for prosecution? These figures came, the first figure, 94% of healthcare workers who came to the attention of the CPS for consideration of prosecution. That figure comes from the CPS at about, I think, 9 years ago. 94% not prosecuted, and I suggest that indicates a pretty excessive referral. Now, inevitably, of course, not every case that's referred to the CPS for consideration is inevitably going to result in prosecution. That must be right. But the fact that 94% of people were not being prosecuted indicates that there were an awful lot of unnecessary cases being investigated and ending up with CPS, even for a decision then not to charge. In relation to conviction, well, the rate, it rather depends on what period one looks at, but certainly less than 50% of cases were resulting in conviction, and that's against a national conviction rate for CPS of about 80% across the board in relation to all offences. And indeed, that also suggests that there was excessive prosecution. Not necessarily a huge amount, but certainly not insignificant, that the wrong cases arguably were being taken forward for prosecution. Well, how does that change? Well, I think in large measure it has changed through the case of David Sellew, the surgeon who was convicted of manslaughter and indeed had served his sentence of imprisonment before then his case came to the Court of Appeal. And I should perhaps at this point just briefly pay tribute to the late Jenny Vaughan, who was instrumental in ensuring that David's case did progress in the way that it did to the Court of Appeal. And it has, it's obviously desperately sad that poor David's experience should be a benefit, but whilst plainly not to him, it certainly is, I think, now to the law and indeed to others. For this reason, that the Court of Appeal in his case makes it plain that unless the direction given by the judge to the jury is of the equivalence of that in Misra, or indeed the case of Dr. X that they describe, who is in fact Dr. Kokani, unless there is something of that significance available as a direction to the jury, it's not going to be satisfactory, it's not going to be appropriate. They are bound by Adamoko, the Court of Appeal. They can't say, yes, there should be a particular formula. What they were doing, though, is saying, look, we can't give you a precise formulation, but unless you're coming up to that very high bar that's established through Misra, that's not going to be enough. It has to be something of that nature. Interestingly, the trial judge in the case of Dr. Kokani was Mr. Justice Globe. And Mr. Justice Globe found himself on the Court of Appeal bench for the purposes of David's appeal. and perhaps that was an illusion of a helpful illusion of circumstance, but it meant that at least there was somebody with some sound and sensible thought as to the nature of the direction which should be given. David's conviction, of course, was quashed. Well, of course, it's not necessarily going to be the case that the right direction always gives you the right result. I put query, wrong result. It's for others to judge, I suspect. In the case of Dr. Hadija Bawagaba, she got a direction which was compatible with Misra. And of course, Dr. Misra and Dr. Srivastava were both convicted on that direction, as was Dr. Bawagaba. But I do suggest that at least that very high bar is an infinitely better position than the one that we had before it. Well, of course, with a large number of people under investigation, and large in this context, I appreciate is not huge numbers, but bearing in mind the damage that the investigation can do, it's significant if it's just one. But with numbers of people under investigation, with what had been happening with David Sellu and Hadija Bawagaba, the then Secretary of State for Health, Jeremy Hunt, decides that he's going to have a review and appoints Norman Williams to conduct that. And we had the opportunity to present evidence to that. And indeed, it was rather satisfying to see that a number of the suggestions we were making were actually taken forward. And I say that not out of any sense of self-aggrandisement, but rather more as a compliment to Norman Williams. There are inquiries which and reviews which are undertaken which don't produce a very great deal, and there's not an awful lot of listening. I certainly wouldn't make that criticism of Norman Williams. I think there was an awful lot of listening, and I think an awful lot of benefit that's come in consequence. One thing that he recommended was that there should be a common statement of the law. And indeed, with the position which had presented, the law was perhaps misdescribed on occasion. And indeed, in my view, as I've made plain, I don't think that there was an adequate description available from the Chief Coroner, for example. But the common statement of the law that's agreed between defence and the prosecution, we were very happy to take part in that. We were a proponent of it. Better guidance for coroners. Again, the law note that was available not entirely up to date, and making it plain, obviously, that there is a very high bar. Better guidance for the police in their SIO guidance. SIO, forgive me, Senior Investigating Officer guidance available in relation to gross negligence manslaughter. That guidance didn't even have an explanation of the law available to a senior police officer, and indeed, at the same time, the police officer was expected to explain the position to an expert, because ordinarily expert reports are obtained by the police. So something that was really rather hopeless at that point. What else does Norman Williams recommend? Well, some improved learning for the police, a virtual police unit. We'd put forward the idea that, in fact, the better course would be to have a national police unit. That might seem slightly strange, that we would be suggesting improvement on the police and having a national unit. That was really put forward with the idea that it would be hugely helpful to have people not involved in an investigation where they're learning. There's a reinvention of the wheel each time. Because, of course, if things are done on an individual force basis, it's rare to have a situation in which the same individuals are available who were involved previously in an investigation. Indeed, that force may not have had any such investigation for a long time. So a national unit made sense in terms of trying to speed the process and enabling people to sort wheat from chaff. Well, the best, with some resistance from the police, that Norman could come up with was a virtual police unit. But it's something. Better training and guidance for experts was another recommendation, and indeed in a number of areas, a better understanding of human factors, which I think is hugely important in this area for those involved in the assessment process. So what have we got now? Well, these are two web addresses you can go to. The agreed statement of the law, it didn't quite happen. We were making progress. And I have a little sympathy with the CPS on this. They decided that at the same time they need to be putting forward, as a prosecuting entity, their understanding of the law, come what may, in relation to whether or not there was agreement. And so wasn't quite taking the ball and running away with it, but they certainly decided to set out detailed guidance in terms of what they considered the law of gross negligence manslaughter to be. Now, I don't make huge complaint, because although I wouldn't have produced quite what they've done, I would give it a fair amount out of 10, and I suspect because they went to appropriate leading counsel for guidance, but certainly infinitely better in terms of their understanding and indeed then available for promulgation. Now, what else? I've put here the web address for the Chief Coroner's law sheet. Initially, the Chief Coroner, understandably, wanted to wait for what the outcome of the joint discussion might be in terms of the common statement of the law. And there was some reluctance to move forward with that. Eventually, though, the recently departed Chief Coroner decided that it was going to have to be revised, and he took it upon himself to make amendment. Again, it's not quite as I would put it, but it's significantly better. It does at least refer to the case of Misra as a starting point. So we're left now with suitable guidance and statement of the law from CPS, and indeed much more helpful guidance for coroners in terms of where the bar might be, in terms of do they need to refer something to the police or don't they? So it seems to me, where have we got to? Well, something of a pendulum. We've moved from one side, and I think we've moved well past halfway and on the upside. Slight difficulty, of course, is that weights tend to come back in the other direction. Not everything is perfect, and there's always the potential for re-evaluation by prosecutors or a reconsideration. So I think we have to be alert to how things may change in the future, but certainly I think significantly better than the position that we had. Now, let me tell you something, if I may, about police investigation and how things move forward. Well, ordinarily, something will be referred by a coroner. There may be a complaint from the family. Rarely from a trust, but it does occasionally happen. And it's something that's usually prior to any inquest hearing. Well, what can the police do? They will occasionally arrest. It's relatively rare, but in my experience it has happened more often than not, and significantly more often than not. It's a voluntary attendance. In other words, a mutually arranged time when somebody should attend at the police station on a voluntary basis without an arrest taking place. It is effectively an offer that one can't refuse, because of course if one does refuse, then grounds are given to the police for making that arrest. So there we are. The police operate in this area to an annex in the murder manual. Certainly they used to. The Association of Chief Police Officers wanted to have an annex in their murder manual dealing with deaths in serious incidents in healthcare. And this is something where we contributed behind the scenes to setting out what it's like for doctors, so that the police can be best assisted, and so can the doctors. And indeed, there's consideration recommended for providing significant disclosure, so that ordinarily it won't be a case of the police withholding the medical records, for example. Those are provided well before the interview takes place. That is the ordinary course of things. The police are encouraged to consider the interview environment, and the possibility that it might be something held away from the police station. And there's a recognition of the stress involved. Indeed, I can remember one particular manslaughter interview involving a doctor where the interview environment wasn't a police station. It was at an interview facility designed to look like offices, because the people interviewed normally would be vulnerable adults and children. We walked into a holding area to await the interview. It was filled with lots of children's toys and a number of items of children's literature. The first item I laid my eyes on was "I want my potty," which probably pretty much summed it up for the poor client. But there is at least an attempt on occasion to try and recognise and understand the stressful situation that doctors will be in. More often than not, though, even if there's no arrest, the interview is going to be in the police station. And indeed, specially trained officers are usually involved. The Met, for example, will use individuals from their murder investigation teams. The difficulty with an investigation on GNM, it seems to me, is that no mental state's required. And indeed, recklessness, if one is looking for a potential mental state to indicate possible culpability, recklessness is thought of possibly as the most guilty state of mind. That means recognizing a risk and going on to run that risk. And it seems to me that if one departs from the straight and narrow in medicine with clear lines and accepted ways of approaching things, there is the danger of being perceived as the risk runner. Perhaps if I asked you all, when you last prescribed, did you look at the drug in the BNF? And if you didn't, weren't you running a risk that you might have misprescribed? Would that be reckless? Now, I throw that out there. I'm not suggesting that that is. It's a facile example, but maybe it makes the point that departing from the straight and narrow can bring you into that concept. Recognize that the police interviewers are going to be specialists, but they may well be asking questions with the additional benefit of some expert guidance. And indeed, there are situations in which the interview will be held with experts actually listening in to the interview. There's an element of pressure because on occasion, apart from simply going into a police station, interviews take place in the custody area. Most interview facilities in a police station, inevitably and for sensible reason, are in the custody area. And going into a custody area means you're going into an environment which feels like a prison. There are locked doors, steel doors, bars. It's not a comfortable place. Most of you, indeed, let me put it a better way, all of you, hopefully, will be in unfamiliar territory. Well, the start of the interview, the police give the interviewee their rights. That includes a requirement to give the caution, which is you do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. Well, what does it mean? And the police will be concerned to make sure you do understand what it means if you're interviewed. Well, the starting point is you don't have to say anything. There's no obligation to say anything. The difficulty is if you don't, it may harm your defence, your veracity may be questioned. If later prosecuted, you do say something and put forward an explanation. Or indeed, if you say something at one point in the interview, but later you vary it in court. Again, a questioning potentially of your veracity. And anything you do say may be given in evidence because it's being recorded. So what are your options for an interview in these circumstances? Well, one is answer questions, obviously. Another is to say nothing. And a further one is to provide a detailed statement and then say nothing. Of course, answering questions means that if you make a mistake, well, it's all being recorded. And indeed, any variant that you might then put forward if you are prosecuted, people can question your veracity. If you say nothing, well, you protect yourself against that danger. But of course, the difficulty then is if you are prosecuted, you haven't said anything at all at interview. If you provide a statement, well, you are mentioning when questioned something. So you could provide a statement and then say nothing, which may then protect you in terms of making any errors. And indeed, in some measure, for that reason, it is by no means unusual. In fact, it is profoundly unusual in my experience, and it's not just me, it's other solicitors experienced in this area, to have a situation in which someone will either say nothing at all or answer questions. It is by far the most common to provide a detailed statement, and indeed that is not a surprise to the police when that option is taken. The aim here is not to hide things, it's to try and be complete and to be accurate and avoid making mistakes, which can easily be made in a very stressful situation. I remember my very first interview in which the client was asked fortunately a multiple question, which ended with the words, "And we think you've been grossly negligent, don't you agree?" And where the doctor answered yes. And he didn't mean that at all. Understandably, the stress of the situation had got to him, his brain had switched off. It avoids that kind of hideous mistake. And indeed, it can also avoid the trap of an inadvertent acceptance of recklessness. So very often, detailed statement is the right way to go. And it seems to me here that the detailed statement and getting it right at the outset can be crucial. Be that in the reflection document, an account that you might be asked to put forward for the trust, a report for the coroner, but the statement for the police too. Getting the account right at the outset, going through things very carefully with your MDO, I think is imperative. Well, what happens next? The police don't decide about prosecution. They may seek expert advice. Ordinarily would be expected to do so. But the decision about prosecution is taken not by the police. All matters, all prosecutorial matters fall to the Crown Prosecution Service, and the unit that deals with the medical cases for gross negligence manslaughter is the Special Crime and Counter-Terrorism Division at CPS. And this is one area where I seem critical of CPS. They certainly have got it right, in as much as they've dedicated this particular division as a specialist unit. So they're much better able to see the issues than otherwise might be the case for CPS prosecutors who aren't routinely used to dealing with these cases. But that's where they go. But there, of course, can be, I'm afraid, still a significant delay. As a rule of thumb, I will be telling a client involved or embroiled in an investigation that investigation is likely to last at least 6 months. We sadly have experience of 2 cases which took over 3 years before a decision was made to charge. I think that would potentially not be the case these days, but those cases aren't that long ago. So if the decision is made to prosecute, what would you do? Well, I'd say make sure you've got a good solicitor putting together a team of experts. And forgive me, of course, I want to suggest that the MDU might provide that service. But again, this isn't self-aggrandisement. I simply make the comparator with the average high street solicitor. I mean, no criticism, but this is an area where obviously things are hugely complex, and having people who have experience of medical matters and understanding what's involved with medical matters generally, even before you get to things like systems and so forth, I think can be hugely helpful. And indeed then in knowing what team of experts to put together on any given case, making sure then that a team of experienced barristers can be assembled. The statistics on this, I've indicated a little earlier about the CPS success rate. I said it's under 50%. Our experience is that it's about a quarter of cases prosecuted result in conviction. More generally, I think, and again, it rather depends on the time period that you're looking at, but more generally, I think it's about a third of cases end up in conviction. Let's say our rate's about a quarter. I should mention a little bit about finance. That may seem slightly otiose in this sense that you, of course, if I may say, have had the good sense to be a member of an MDO. The difficulty is, if you're not, you're then falling back on some other resource. In terms of the interview, free and independent legal advice is provided at the police station for the interview. What that doesn't cover is anything preparatory to the interview. So if anybody were taking the approach of, well, I'll produce a statement, sitting down with a solicitor beforehand is going to have to be paid for. It's only the attendance at the police station that's covered. What happens if you're prosecuted? Well, if you succeed, will you recoup your costs? Well, the answer is you'll recoup some costs if the judge orders it, but only if you have first applied for legal aid and been turned down on financial grounds. If that applies, if you've done that, then you can get some costs back. What you won't get back is everything, because the government is obliged to reimburse only the fees at legal aid rates, which are significantly below ordinarily rates that a privately instructed lawyer would be charging. And so there's going to be a significant gap. The other point that I'd make is that there are inevitably legal aid constraints. The public purse is not bottomless. I have to say, for my part, in being an MDU solicitor for 24 odd years, and indeed having worked for the MDU since 1985, if I've asked for something in relation to a prosecution, I've got it. If I make a case for needing something, I'm given it. If I want to instruct a particular expert, I get it. And that resource is hugely helpful. Well, what about the future? Where may we go from here? Well, the difficulty is when people say reform, very often it's easy for people to reach for an off-the-shelf proposal. And indeed, in 1996, the Law Commission put forward proposals on involuntary manslaughter and recommended the concept of killing by gross carelessness, which had as a requisite that the person's conduct should fall far below what can reasonably be expected of him in the circumstances. Well, I'm not sure that falling far below takes you very far along the way to a successful or satisfactory, I should say, definition. Far below, how far? It's not quite the language of Misra, of the even very serious mistakes are nowhere near enough. or that something has to be truly exceptionally bad. I know on which test I'd like to take my chances, and it isn't this one. So I think if people talk about reform, I would say this: beware of what you wish for, certainly in terms of legislative reform through Parliament. You don't know what you're going to get, and if it's something like that, I don't think it's going to help. It seems to me there is a genuine benefit from David's case. We've got a strong test. It's not going to be perfect, but that test or an equivalent is going to be expected in every case. Now, I'd finish with this. I don't think anyone suggests there should be no prosecution of doctors at all. Where there is something with the worst recklessness, the equivalent of driving down the motorway on the wrong side and deliberately running that risk, it seems to me it's difficult to call for an amnesty on doctors generally. But I do significantly question what good prosecution really ever does. It seems to me we're very good in this country at fixing the blame and not the problem. The Japanese have that proverb, fix the problem, not the blame. Prosecution doesn't do that. And one can look at the Ving Christine cases as an example. 3 prosecutions. The issue wasn't resolved by prosecution. What happened was that the chief medical officer made or required Kent Woods to undertake a review, which he did, and I think very successfully, because the recommendations which followed that, in my understanding, have resulted in no inadvertent administrations of vincristine intrathecally since. That's the way you sort things out. Prosecution doesn't get us anywhere. Thank you very much indeed.
Ian, thank you so much. That was a fascinating run through. If I used the word daunting at the beginning, and I find it daunting just thinking about it all, actually. So we've got some questions, if that's okay. And I think the first one is probably going to be a how long is a piece of string type question. But how long, how long do these things take? Of course, it's going to vary from a case by case basis. But
yes, it does.
Time, what sort of time do you see with cases?
I think part of the problem is still the fact that the police, because there isn't the national unit and the individual officers who are dealing with it are having to do an element of reinventing the wheel. It can mean that there is a fairly long process still, which is why I would still stick to the recommendation that people don't expect change out of 6 months as a starting point. One of the things that I think is good is that CPS, we had raised concern that there needed to be a quick sorting out of wheat from chaff, with the idea that people should be getting expert reports quickly, a relatively early stage, because it can be that an expert can cut through it and say, look, now you are not in the right territory here, and that comes quickly. And one of the things that can also be beneficial is early advice from CPS, going to special crime very, very quickly to say, look, this is what we've got, guide us. And that's one of the recommendations now on the CPS website, that police, or they encourage an early coming to, if you will, to special crime to get some guidance. I think that brings it down. Are we looking at cases which take more than a year to get to a decision? Yeah, it can happen. I think the important thing, from my perspective, that I've seen change is a marked decrease in the amount of investigation. And so maybe I've been a turkey voting for Christmas, but I have to say, because I don't think prosecutions fix things, I'd much rather be the turkey. I'd much rather see less investigations, and by the same token, then less prosecutions. And I think that is coming about.
Okay, thank you. And we talk in the MDU, we talk about multiple jeopardy, and I guess there's always this the police investigation is going on, and one thinks, well, what else is going on, and what is there communication between the police and the GMC, and what happens there? So that's another question, really. What will the police tell the GMC, and further down the line, when the police close their case, hopefully, does that mean automatic resolution by the GMC? I know the answer to that one. I'm just sort of putting it out there so we can discuss it, but yeah.
No, I'm afraid, well, sadly not. And of course, it's another reason why you want to make sure you're absolutely getting it right and nailing it in the police interview. Because even if you aren't prosecuted, if you've made a bad job of it in the interview, and police interviews really are stressful experiences for people who are not used to it. And by definition, decent people are not used to it. If you are used to it, well, there we are. But if you're not, it's not an easy process. It is daunting. And of course, all of those mistakes then, even if you're not prosecuted, potentially are available for the GMC to have a look at. So getting it right is important because, yes, as night follows, are there cases where I've had a GNM where it hasn't gone to the GMC? Yes, but they are very rare.
Yeah. And I think there's a thought, isn't there, that sometimes, you know, when the police close, the thought is that therefore the GMC will close straight away, and unfortunately it's a separate process and the GMC will run their investigation as per. So I think it's, again, that's the reality of the situation, isn't it?
I'm afraid to say this. I think there are 2 points on that. The first is that, of course, the GMC isn't interested in causation. Causation can be an issue as to whether whatever happened actually caused the death. GMC is looking at the conduct. Causation may be a parallel, but they won't consider themselves confined to that, and they won't say to themselves, well, we will only move forward if there's gross negligence. So they look at it and say, yeah, well, we have a different position.
Yeah. Thank you. I'm just going to look through. There's a few questions coming in. There's a few people have asked about the situation in different jurisdictions, and obviously we can only comment on the UK, maybe the Isle of Man, Channel Islands. But how is the situation different in Are you able to give us a brief snapshot?
Yeah, well, I think SRA requirements would mean that I have to say that I can't give you advice about other jurisdictions. But no, in all seriousness, Scotland, for example, has the offence of culpable homicide. And whilst I wouldn't want to give you advice as to precisely what culpable homicide amounts to, I do wonder if the Scots, and I have to declare an interest, I regard myself as being Scottish here, have got a better public policy approach to it, because to the best of my knowledge, there has not been a prosecution for culpable homicide of a doctor in a medical context in Scotland at all.
Okay.
Wales, I should just add, is obviously part of the same jurisdiction. England and Wales is one jurisdiction. You mentioned Isle of Man. Of course, there was a prosecution on the Isle of Man recently, as you and I know. That was something which where the Isle of Man borrows heavily on the English common law. So essentially our position, albeit that they're not obliged to follow it.
Okay. Thank you. A few people have also asked questions about vicarious liability, and I think this comes out through organisations where employees are practicing and something happens, then how much would a GP partner or an employer be liable for something that is maybe an act or omission of that employee? And again, it's impossible to be specific because every case will be different. But have you got any thoughts on that in the most general terms?
Well, I have to this extent. Not vicariously liable in the sense of a gross negligence manslaughter. So it doesn't apply as a concept in quite the same way. In a GP practice, would the partner, for example, be considered vicariously liable for, let's say, a salaried GP? The short answer is no, unless the individual actions of that partner were considered to be grossly negligent. But there would have to be gross negligence to the same kind of Misra formulation on an individual basis for that individual. What does come into play, though, is the potential for corporate manslaughter to apply. Now, this doesn't apply simply to corporations. Corporate manslaughter offence covers partnerships as well. So it is conceivable that in relation to a matter where there might be considerable systems failings, for example, that is something which then ends up being looked at on a corporate basis. But it would be the partnership as opposed to the individual doctor, but the partnership in the same way as it would be for the trust. To the best of my knowledge, there's only been one prosecution of that kind of entity in the context of healthcare. It was of a trust. There is another one in play at the moment, so we can't talk about that. But it is relatively rare.
Okay, all right, thank you. I think we've got time for just a few more questions. Someone asking about, oh, someone's come in with a, you will be able to explain this. Can you explain what you mean when you refer to the Misra case? Just a quick one, and that's, I know that's the case that Ian referred to earlier on, but just a quick recap with the Misra case, Ian.
Sorry, in terms of the law on it, or the circumstances?
Yeah, just the circumstances, yeah, just very briefly.
Well, essentially 2 junior doctors not attending to things in the way that was considered appropriate in relation to a patient in hospital. The consequence of that is the judge then giving a direction to the jury. That direction is, as I've indicated, something that was powerfully strong. It was something which indicated that very serious errors of judgment, very serious mistakes are nowhere near enough for the crime of manslaughter to be committed, and the conduct has to be truly exceptionally bad, setting that bar up very high.
Okay.
Sorry, forgive me. I hope that's what the question was after. I do beg your pardon.
I think they mentioned the law on it. They want some that probably will be in the slides, actually, a link in the slides, hopefully. So hopefully when you get the slides at the end, that will be there. Okay. Now, someone's asked a really good question here about human factors. So, you know, the question is, are human factors considered in the defence? You know, such as circumstances that might have contributed to the doctor's behaviour or mistake at the time, or, and so forth. That's a really good question. So, thoughts on that one, Ian?
Yes, the short answer is yes. I have obtained assistance on occasion from Jim Reason, Jim of the Swiss cheese model. Looking at trying to break down why it was that somebody's mindset came to doing something which was profoundly dangerous. And I have to say he was hugely helpful in explaining things to me. And it's one of the reasons why I think human factors training and understanding on the part of prosecuting authorities is particularly important, so that one can, even before we get to a defense where I'm lining up my experts. Interestingly, in the first case in which I tried to deploy Jim Reason, the Crown Prosecution Service lawyer indicated to me that they were going to object to him being an expert because he wasn't a doctor. This being Jim Reason, who was responsible in part as a member of the panel which drew up Organisation with a Memory for the NHS. Quite extraordinary. But there we are. Things have much improved. Last time I proposed to deploy Jim, not a squeak as far as that was concerned. But interestingly, I certainly haven't been convinced or aware that prosecutors are necessarily going to systems people to have that understanding from an expert. Certainly from my perspective, yes, I want to break it down. I want to understand how something came about. I want to understand how it is that somebody's blinkers were put on so that they didn't see something that might have been thought to be obvious because they were concentrating on somebody else, because of another person's mistake, or some information that they got, or a fundamentally inherently deficient system.
Yeah, and just sort of transferring that over to a GM. I know we're talking about criminal prosecution, but just switching over to the GMC, and someone's asked about experts in the GMC investigation, and I guess, you know, similar expert panels would be used in both, and that would be a crossover with experts in human factors as well.
Yes, that's right. I would see no less a reason for involving a human factors expert at the GMC than in the Crown Court. Absolutely right. Yeah. Yeah.
Okay. Thank you, Ian. I mean, I think that's, you know, we've covered many questions. There are some questions we won't cover, so I'm sorry about that. We haven't got around to everybody's questions. You know, it was it's a fascinating talk. It's a fascinating subject, and hopefully one that for most of us will remain purely theoretical, because, you know, just like I said, just thinking about it, one's heart rate just goes up a little bit. Of course, it goes without saying, you know, that if anyone gets, you know, an inkling of anything going on, contact your MDO, contact us straight away. Yeah. And, you know, Ian, you made a point about, you know, getting it right early on if you're asked for a statement. I think it starts early on, doesn't it? So as soon as you're asked for a statement with anything, we are here to help, you know, so write
Absolutely.
in, let us know how we can help, and we can hopefully give you some pointers. So we're a little bit early. It's a warm evening, certainly where I am, so I think we'll probably draw it to a close just there. Once again, I think when this is finished, you know, you'll get the opportunity to give some feedback, and we would find that really helpful. So if you could do that, that would be fantastic. Thank you, Ian, for
My pleasure.
fantastic talk, and thank you everybody for joining us. That's it. Good evening.
Good evening.